If you want to protect your brand, filing a trademark application is certainly a recommended step. However, it should not be your first step. You should always start by doing a search to make sure you understand exactly what the trademark office will see when they look at your application. That may avoid costly mistakes of both time and money. When you do decide that it is time for you to file a trademark application, you want to make sure that you have all the information together that you'll need to put into the application. What's the name of the company they'll be filing for the application? What's their legal address? What type of entity are they and where are they registered? Those are very simple bits of information about the applicant itself. Next, you want to understand exactly what brand you want to register. Is it a plain letter mark? Is it a design? Is it color? Is it stylized? What exactly are you trying to register? And make sure you have a clear copy of that to submit to the trademark office. Next, what goods or services will you be selling under your brand? Make sure that you've carefully described all of these goods and services, and if possible, you're using the identifications that the USPTO has pre-approved. Next, you'll need to understand whether or not all of these goods and services are currently being sold under the brand, or these are things you intend to do as this impacts the filing basis. All of these things are some very basic information that you'll need to be able to file a clean application that's not likely to be faced with informal refusals. Make sure you work with a trademark attorney to avoid many of these common mistakes. The supplemental register is one of the two registers that the USPTO offers to trademark applicants. The principal register is the preferred register. The supplemental register is where descriptive marks go to live for a period of time until they're able to acquire distinctiveness. Both registers offer people the ability to use the circle R to show that the brand has been registered, and the registration on either will prevent future applicants from getting a registration based on likelihood of confusion. There are a few presumptions that are missed on the supplemental register, such as your presumption of ownership and your nationwide exclusivity. However, these are well worth the price to make sure that you're actually able to get on some sort of register. The supplemental register is an excellent place for descriptive brands to go and mark time until they're able to prove that they have acquired distinctiveness. This often takes 5 years or longer and a lot of effort, but gives you a place to reside until you're able to work your way onto the principal register. A trademark attorney can help you avoid many refusals that are common in the process. Of course, a lot of these are the types of refusals that the attorney seeing day in and day out can help you avoid that are more ministerial in aspects. For example, have you named your state correctly, your type of entity? However, trademark attorneys also know a lot of nuance about what the trademark office does and does not like to see. For example, when you're submitting a specimen of use showing that you're actually using the brand, there are many nuanced rules that the trademark office has, and a properly trained attorney can help you get through that process much easier. Also, when the trademark office issues a refusal, that refusal will go to the trademark attorney. He or she can help you understand exactly what the refusal is and what you should do to overcome that refusal. Hopefully, the refusal is not a surprise because the trademark attorney also would have told you about these types of refusals ahead of time and had a game plan for you. Legal guidance can save time, money, and frustration by preventing costly mistakes. A strong trademark application is key to protecting your brand. Don't take risks with your business. Reach out to Initiate Protection Law Group today for expert trademark guidance and support.